Welcome to Deals and Disputes with the Webb Law Group.
Hello and welcome back to Deals and Disputes with Webb, Allbritton, and Gentry. Today's guest is Cole Geist, an attorney with the firm who focuses on construction litigation, employment disputes, and business matters. My name is Kevin Rosenquist, and today we're talking about what to do if you've been called for a deposition. Cole, welcome. Good to see you.
Good to see you too, Kevin. Thank you for having me.
So let's just start at the top in case anyone doesn't know. What exactly is a deposition and why might someone be called to give one?
Okay, so a deposition is going to be a formal process. Typically takes about a day, where you're going to sit down with an attorney who has given the notice for the deposition. So what's going to happen is you're going to receive a notice and potentially a subpoena attached with that too. And so then it's going to be this full day where you're going to sit down and you're going to have a lot of questions lodged at you as the deponent. And these questions are going to be leading, direct questions that can span from where do you live, how many kids do you have, to why did you run that stop sign? It's going to be a full range of questions. There's really very few questions that are off limits in a deposition. But it's this question and answer scenario, kind of similar to what we're doing here, but much more formal and important as far as the case goes on. Those words are going to live for years and years to come.
Yeah, I've actually been deposed a couple times, but it wasn't for anything. It was something related to something else. I wasn't in trouble or anything like that. But that is often a common misconception, right? Like that a deposition notice means you did something wrong, but you don't necessarily have done something wrong.
No, not necessarily. I will say, if you're being brought into a deposition, it means something in the world has gone wrong. There is a lawsuit out there.
Right.
And so whether you're part of that lawsuit or not, that could depend and change and vary. But ultimately, somebody's not happy with another person. And so you're getting called in and brought in to help explain that, or what your role is in that, or what you observed. It might be a case where, party X rear ends party Y, and you were eating a hot dog on the street and saw the whole thing. You didn't do anything wrong, but they're going to bring you in as in a deposition to elicit your testimony for what you observed during the car wreck.
Why that instead of just a statement? Why is there a need for a deposition?
Well, generally you will have given a statement. You'll have maybe potentially a police officer report statement, but a deposition is going to be much more similar to trial. A statement is not given under oath, and whenever you're talking to a police officer. And so a deposition, the first thing that's going to happen is you're going to be sworn in, and it's going to be that same oath or swear in that you do in front of the jury, and that'll be done by a court reporter. And then you're going to be asked questions in a question answer scenario very similar to what you see on TV in a courtroom. The attorney's going to ask you a question, you're going to give an answer. There might be objections, there might be back and forth between the attorneys, but that's why it's different than a formal statement, because a formal statement is going to be, what do I want you to know? What am I going to write down? Mm-hmm. The deposition is going to be, what does the attorney want to know? And he's going to ask me those questions, and then I'm going to have to give an answer to them. And so in a statement, I might just give the facts that I think are important. And this party, party X ran the stop sign and hit party Y. But in a deposition, I might be able to elicit questions as far as, what was party Y on their phone? Did party Y also run the stop sign? And so then you can elicit more information than what maybe have just been given in a statement.
One of the things that surprised me when I was in a deposition was that even if there's an objection, like the lawyer who was, I guess, on my side, if you will, wasn't my lawyer, but like if they objected, I still had to answer the question. Is that pretty much the case in every deposition?
That is generally going to be the case, yes. And that's, I'm sure we'll talk later about the importance of having an attorney there to represent your interests. But in Texas, we have a more simplified version of lodging objections and depositions. You'll hear objection form. And I'm not sure where your deposition was taken, but essentially, if I'm defending a deposition, you'll hear me throughout say objection form. And what I'm doing is I'm saying that I am objecting to the opposing counsel's question. But in Texas, to simplify it, I don't have to give the Texas Rules of Evidence basis for my objection whenever I object, how I do in trial. In trial, I'll have to say objection, give my basis, hearsay. Objection, best evidence rule. In a deposition, I'll just do form. Then the deponent will answer the question unless I, as his acting attorney, instruct him not to answer. And there's going to be very few situations where I instruct you not to answer. It's either going to be the question dives into a privilege, whether it be attorney-client privilege, spousal privilege, clergy privilege, or I think that the objection is generally lodged for purposes of harassment. Objections like for irrelevant information, you're still supposed to answer that question.
Right.
So what you'll hear is, I'll say objection form. The person that's taking the deposition, the attorney that's taking the deposition can say, well, what's your basis? And then I have to be ready on the spot then on the record to articulate my basis for the objection.
Okay. And it can be kind of an intimidating situation for people who've never been in that situation before. We all watch Law and Order and the court TV shows or whatever, and you start to see that stuff, and it kind of automatically puts you sort of in a defensive position, maybe even in a little bit nervous. How do you prepare people for depositions to kind of help calm their nerves, to help make them understand what this process is all about?
No, absolutely. And truth be told, it is meant to be intimidating.
Okay.
My practice court professor told us that the cross-examination was the greatest mechanism for the finding of truth that mankind ever invented. And you see those big moments in like A Few Good Men.
Yeah.
You can't handle the truth, and that's cross-examination meant to rile you up, put you on the spot, get the blood pressure high, and elicit that truth, and also to point out inconsistencies in stories. And so now a trial is going to be next level, because you're going to have a judge who's elevated, physically higher above you, looking down at you. You're now lifted above, while 12 of your peers are staring at you, and you've got this room full of people. You just swore before God that you're going to tell the truth, and you're being lodged, leading questions at you. It's not meant to be comfortable.
Right.
And so a deposition is similar in that you're going to take that same oath. If it's a video deposition, you're going to have lights on you. You're going to have a camera pointed at you. You're going to have, a man or woman that's a court reporter writing down every single word you say. And so it can be overwhelming for some, and that's why at our firm we're going to go through good measures to make sure that you're prepared for that, and that you walk in know exactly what this is how it's going to play out, what it's going to look like. Typically we'll do it at our firm. If it's going to be my client getting deposed, it's going to be on our home turf, and so that way I can take my client in, show them the room. You're going to be sitting here. This is what the lights are going to be like. And walk through that, so that way it becomes more comfortable. And that first time you're sitting down, it's not that overwhelming, man, I don't feel comfortable, and you can give the best deposition that you can give.
What kind of mistakes do you see people make, whether it's in the preparation or during the deposition? What's common for that you might want to get out there to help people maybe prepare?
So one of the biggest mistakes that I see quite often is not listening to the question asked and then oversharing in an answer. And do not mishear me. Tell all of our clients and anybody that we prepare for a deposition, the most important thing in this is to tell the truth. And because you're taking an oath, before the state, before God, that you are going to tell the truth. And so that absolutely must be the first rule that you apply to any deposition. Tell the truth. But don't overshare. If a question is not lodged directly at you, then you don't need to just start giving information that was never asked for. And so I've seen just all of a sudden, the case is all focused on this one issue, and then out of left field, a question wasn't even asked, but a deponent goes and goes off on this tangent over here, and now all of a sudden the whole case turns its focus, looking over this way. So pay attention to the question that's being asked, answer it honestly and fully, but don't dive into details that weren't asked or weren't elicited by the attorney that's taking the deposition. I think your second part of your question was in preparation, some of the issues that I see. One is over worrying about it. I mean, this is going to be like, you're just telling the truth. And if you're telling the truth, then your deposition is going to go fine. Mm-hmm. So not to put too much worry on it and losing sleep, and those things. But then sometimes I will see lack of preparation, and not wanting to show up with your attorney and walk through potential questions that you'll be asked, not wanting to give it the time of day, and just being frustrated in general that you're being called in for the deposition. I mean, I'm sure when you got called in, you're like, why am I even here?
One of the
which is
times
part
I
of what
had no idea what I was doing there. Yeah.
I've seen that before.
Yeah, it's a little intimidating, but yeah. And one of them, I definitely had a very ill-prepared lawyer, I gotta say, because they didn't really prepare me for anything. So yeah, I appreciate the fact that you want to sit people down, show them the room, get them comfortable, make them understand what they're going to be asked, go over things. That makes a lot of sense to me. But one of the things that I remember experiencing was some of the questions were confusing, even a little tricky. Like I wasn't sure how to answer them, but I know you have to answer them. How do you coach your clients in understanding the process and how to handle those tricky questions? Because you can't have a dialogue with your lawyer during the deposition, correct?
That is correct. You can speak to your attorney during breaks, which I will make a note that I do recommend taking breaks. 45 minutes to an hour, you should take a break. This is a marathon, not a sprint. And so taking breaks gives you the opportunity to get some water, reset your mind, talk to your attorney, and then go back in with a new mindset. And then that leads me to one of my other points, and that you brought up is the deposition. A good attorney that's taking a deposition is going to try to make this feel like you and I are just sitting down for drinks, having a conversation, and even potentially we're on the same side. That is not the case. An attorney takes an oath to zealously represent his clients, and that does not mean just at trial. That means from day one, whenever somebody hires me, I am going to zealously represent them in every action I do. Everything is calculated. Everything has a reason. And so if I'm asking a question at a deposition, there is a reason behind it, and it is to zealously represent my client.
Mm-hmm.
And so if you're taking a deposition, or if you're giving a deposition, I should say, you need to know that that attorney is not there for your best interest. That attorney is there for his client's best interest, or her client's best interest. And with that in mind, every question, even those that may come across as tricky, are to serve that attorney's client's interest. So in answering those questions, having that in mind, I'd recommend when a question is asked, if you feel that it's tricky, stop, take a deep breath. There's no urgency to answer that question. Slow down. Think about the question as it was asked. If it feels that it's misleading or that it's a tricky question, it's totally fine to say, sir or ma'am, can you rephrase that question or re-ask that question? I don't understand the way it was asked. And now the attorney can puff up, become aggressive against you, which is why I'd recommend having an attorney there to defend you in those situations, because you don't need to stoop down to their level. Let your counsel do that. But you're never going to be the bad guy if you ask to repeat the question, or you ask for, can you explain that? I feel like it's misleading, because then all of a sudden on the record, it looks like if the attorney's not going to rephrase it, are you misleading the deponent? Are you being this, mischievous attorney that we don't like? So in those scenarios, you are going to get the question re-asked, and that's probably the best thing to do.
Yeah, you brought up a really good point. I think is the slow down thing, and that's hard to do in the moment, especially if it gets contentious. Is yeah, to just take a break, think about the question, think about how you want to answer it. I think that's really good advice and very hard to remember in the moment. What kind of tips would you give to someone to remember that in the moment and how to stay calm and how to stay focused?
Part of that can come with practice, and to be honest with you, that's why I recommend doing sessions with your attorney beforehand, because it gives me the opportunity to sit you down, give you a taste of what these questions are going to be like, and then to practice actually slowing down and working through that. And that goes back to the breaks as well. So to remember it, that's going to be each individual's, the way they remember things in stressful situations. I would just, have a drink there, take a break. If you need that, moment where the question's asked, take the drink of water, slow down, breathe, and then answer the question. Then also remember just to take breaks. I mean, every 45 minutes to an hour, take a break, and then that gives you the opportunity to go speak to your attorney and maybe say, hey, why did they ask this question this way? Where are they going with this? What are your thoughts here? Help me out. Otherwise, your attorney, he or she cannot coach you through this.
Right.
It's unethical. It's against the rules. I'll never do it. No one at our firm will ever do it. We're not going to coach during a deposition, because that's not what we're there for. Deposition is to elicit your answers to their questions in a truthful manner under oath. And so Some of it's going to be on you. It's your deposition, you're giving it, and you've got to remember to slow down.
Okay, so after the deposition is complete. What happens next? What is it used for?
So the deposition is going to be used potentially at trial. The real purpose is so that way, me as the attorney that's taking the deposition, I can elicit the testimony that you're going to give at trial. Because I don't want to go to trial and ask you a question that I don't know the answer to. And so then it gives me the opportunity, one, to evaluate the case. What's being said, who's going to say what, so that way we can analyze and review it for potential settlement, so we know what the case is going forward.
Mm-hmm.
Then at trial, if I'm eliciting questions from you at trial, and now all of a sudden you give me a completely different answer than you gave me in your deposition, I can impeach you using your deposition. And impeach essentially means I can point out an inconsistency in your testimony. I don't want to say that the person is lying, because it may be that they're not, or that they misremembered, or
Sure.
a range of different reasons. But I can show the jury that you are not a consistent, trustworthy witness. And so let's go back to the example of party X, party Y. Party X runs the stop sign. Let's say that you're the witness and you see party X run the stop sign. I take your deposition. You tell me, absolutely, he ran the stop sign. We all of a sudden get to trial and you say, oh, did I say party X? I really meant party Y ran the stop sign. And now all of a sudden my case has blown up, and what we thought was all the facts and what you were going to testify to didn't happen.
Mm-hmm.
In that scenario, I can't force you to change your testimony on the stand. I can point out the inconsistencies, and I can show the jury that you're not trustworthy. So what I'm going to do is pull out your deposition, show where you took the same oath that you now took in front of these jurors, but you told me on 2 months ago, you told me it was party X that ran the stop sign, didn't you? And then you're going to be forced to give an account for why your story is inconsistent. It also draws into your credibility as a witness to recount the observations that you had, and whether the jury's going to believe your side of the story or not. And so that's the purpose of the deposition. Is that way, one, the attorneys know what's going to be said at trial, and two, to hold you accountable to what you said during the deposition if it's inconsistent at trial. Okay.
Yeah, so I think it probably goes without saying that these are pretty important parts of a case, the depositions.
Oh, it's absolutely. It is one of the most fundamental parts of preparing for trial. It's we don't like to call witnesses that we haven't deposed because we don't know what they're going to say. And trial is where everything happens, and so there's very little room for error. And part of avoiding those errors and narrowing that room is knowing what people are going to say, going and getting the depositions.
Yeah, that makes a lot of sense. All right, Cole. Well, thank you very much for giving us that rundown of what depositions are. I hope whoever's listening out there, I hope you guys found this useful, because it doesn't have to be scary, but it is a process. So making sure you understand that, I think, is important. So thank you, Cole, for that. That wraps up today's episode of Deals and Disputes with West, Webb, Allbritton, Gentry. If you'd like to learn more about the firm's attorneys or catch past episodes, visit westwebblaw.com. That's Webb with 2 B's. Thanks for listening. Be sure to like and subscribe and leave a review if you found today's episode helpful. Cole, I really enjoyed the chat. Thanks so much for your time.
Thanks for having me on.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.